Welcome to the 𝗙𝗂𝗏 Elder Law channel. I'm your host, Melissa O'Connor. I'm a Florida-based elder law attorney who does estate planning, focusing on long-term care needs, commonly referred to as Medicaid planning, and I do probate, and I do it well. Today I wanted to talk to you about joint bank accounts and Medicaid planning when the account really only has one owner's money in it. But before I do, I wanted to invite you to schedule a free strategy session with me at eldermeeting.com. So many times when I am talking with families to put in place a Medicaid planning strategy, I'm told or I'm advised that there's a bank account where the person who we are looking to obtain long-term care benefits, their name is on the account with, normally an adult child, right? And the adult child says, but none of the money in there is my parents', right? I just put them on there just because, after my divorce, I just added my parent. And so will that, how is Medicaid going to treat that money? Because it's not even theirs. And the answer is that the presumption is that it's co-owned and that 50% of it is going to be your parents, even if they never dropped a dime in there. That's the default, right? 50-50 co-ownership. And so now that we know what the default is, we have some options as to how we're going to address this jointly held account. One option is that we put planning around it, right? We treat it as an asset owned by the potential Medicaid, applicant, and we plan accordingly. We put in shelter plans to move and transfer the money to avoid or minimize penalty. Another option is you say, that's horrible. Why should I have to put planning in place? It costs, there might be some tax implications to that planning. There could be all different, who knows? They don't want to do the planning. It's all my money. The government should understand that, and I don't want to do any planning. So the option there would be for us to complete an affidavit, right, where all parties will sign and swear that the funds in this account actually belong to, adult child, right? And the reason why do we have a joint account, you have to tell them why. Why would you even do this if you're not going to, have co-ownership? So you have to tell them why you decided to have a joint account. And you also need to be clear as to what the monies that have exited this account for in the past 5 years, right? What it's been used for, right? They'll want to know where the money's coming in from, where the money's going out for, what it's used for, and why they even have this account. Then you just have fingers crossed that the Medicaid office accepts your affidavit and thinks that it to be true and reasonable, and that they're willing to acknowledge and move from their presumption default that it is the applicant's assets, and that it was never their assets, right? And that they will accept it and approve the application. Should they reject it, then you are looking either at a fair hearing where you're going to continue to appeal this and fight for your affidavit, or you might want to just decide that you're going to put some planning in place around those monies now and avoid the costs of hearing and get yourself qualified for benefits quicker. Those are your options when it comes to these sorts of joint accounts. At the end of the day, neither of the options are super great, right? Like, there's nothing perfect in this world, but those are the things that you're facing when you have a joint account, when the money is really just one person's, but yet the co-owner's name needs long-term care benefits. I hope that this information has been helpful to you. If it has, I ask that you like and share with others. And as always, thank you for joining me.